This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael. Today we're chatting with Emily Nong. Emily is Special Counsel in the Construction, Infrastructure and Projects team at Holding Redlich Lawyers. She brings a wealth of experience and expertise acting for major contractors, engineering firms and project owners, including governments, across the public infrastructure, renewable energy and commercial construction sectors. Emily's work spans the entire project lifecycle, from the preparation and negotiation of contracts to contract administration, project delivery advice and assistance with claims and disputes. Emily is also an active member of the legal community, serving on the Queensland Law Society Ethics Advisory Committee and the Society of Construction Law Australia's Events Subcommittee. Today we'll be discussing a range of topics, including the proportionate liability regime in Queensland, recent court decisions impacting construction law, and the unique challenges faced by working mothers in the legal industry. Let's jump in. Emily, welcome to the show.
Thanks for having me, Jennifer. It's good to see you again.
Yeah, you too. Emily, you're on the podcast today, having recently presented a paper at the 2025 Society of Construction Law Australia's National Conference, and you submitted a paper called Rebel Without a Cause, Is It Time for Queensland to Rethink Its Prohibition on Contracting Out of the Proportionate Liability Regime? Bit of a mouthful there. What led to you deciding to submit a paper?
So I think being entirely honest, I was at the time that I put in the abstract for the paper suffering from relevance deprivation syndrome, which is what I'm calling it. So I was on parental leave. My son was about 2 months old, and I felt at that time like I felt quite disconnected from my usual day-to-day in terms of reading and writing and practicing law. And writing a paper for the SoCLA conference is always something that I had wanted to do, and I just hadn't found the time before. And so I thought, probably naively in hindsight, I have some time now, except obviously when you're a new parent with a young child, even when you have time, like you're exhausted, and finding quiet moments when your baby's sleeping to research and write a paper is actually quite a significant undertaking.
Absolutely.
So I got it done, but to be honest, it was a lot more challenging than I expected. But I'm still glad that I did it. I enjoyed the process of it, and it was something that I found, helped bring me back to the law and things that I was missing at that time. But I think probably at that time when I decided to submit the abstract I think I was probably struggling with new motherhood. And then by the time that I got the email saying, oh yeah, we want you to write the full paper, I was like, I'm very much settled in motherhood now, and I'm enjoying that, and I'm good with that. But then I thought, it would be good to get that balance and to use my brain a little bit, even though obviously being a mum and being a parent, it still requires a different part of your brain. But, so it was just an opportunity to feel like I was doing something that I was more accustomed to and something that I felt like I was missing when I was on leave.
Yeah, absolutely. Well, hats off to you. I could not imagine doing that as a new mum, writing a paper and submitting it. So yeah, absolutely. My hat's off to you. You've returned to work now after your maternity leave. What has been your experience of returning to work after your maternity leave as a new mum?
Overall, it's been really positive, and I think I'm happier being back at work and having that structure to my day. That being said, there are obviously lots of moments, particularly in the early days, where I questioned whether I'd made the right decision and whether I'd come back too soon, and feeling moments of quiet heartbreak sometimes about not being able to spend as much time with my son. But everyone's been really supportive. I have a colleague that also came back recently from parental leave, and so we're going through similar things at the same time, which is really nice. And I also don't feel like being away has resulted in me taking any step back, which is really positive. And obviously the same couldn't have been said for, like my mother's generation or even people, returning to work, I'd say 5-10 years ago. So I do think that there's been massive strides made in that respect in the legal profession in particular.
So, have you had any challenges with transitioning back to work that you've had to face? What kind of things have you done to sort of ease the transition?
Yeah. I mean, I think there's the emotional challenges and then there's the practical challenges, as you would know, as a mother of 2 kids as well. But the biggest practical challenge is just basically having a deadline every day because you've got to leave at a particular time to get home and to go through dinner time, bath time, bedtime routine. And so I had the luxury before having my son of, even when I had deadlines thinking, oh, well, if I need to stay back to get it done, like I can do that. And that always provided a sort of level of comfort. Whereas now sometimes I've really got a very hard deadline that I've got to meet before I rush out the door. And so, I mean, the way to manage that has just been to be really clear with communication. And sometimes that does mean having to log back on if I haven't quite finished something or being a little bit late in terms of, not when I say late, like I mean, sending it later in the evening rather than, by 5 or 6 p.m. or something like that. So there's that challenge. I think in terms of some of the other things, comparing myself to both the lawyer I used to be before I had my son and also comparing myself to the mum that I was when I was on leave. Like I can't be either of those things anymore, and nor should I try to be. And I'm coming to terms with just being able to do both of those things and getting a balance between the two has been a challenge.
I think it sounds like you're right in the thick of it right now. And it's a long distant memory for me going through the process that you've gone through. But it sounds like you've got your head in the right place with emotionally where you're at with it. And it sounds like you also have quite a lot of support from your firm, from your colleagues, which unfortunately isn't the case for everybody in the legal industry and just the workforce more broadly. But what do you think that law firms specifically could be doing to provide more support to working parents? I mean, not just mothers, because there's also fathers taking parental leave as well and returning to work. So what are the things that you think that firms could be doing to better support working parents?
I mean, yeah, you're right. Like I've had a good experience and I've been very fortunate, and it's not the same everywhere. Something that I'm really passionate about is making sure that dads get the same parental leave rights as mums, because I do think that that means that fathers are then more involved in their children's lives and ultimately means that women can get back to work. And also that issues about needing to take parental leave in the first place and needing flexibility to be able to, do either daycare or school drop off and pick up and things like that isn't seen as a woman's issue and is just seen as a parent's issue. And so I think a lot of firms are now, they have policies that sometimes lose the distinction between a primary and secondary carer, which I think is a really positive thing, or don't discriminate between whether it's a woman taking maternity leave or a man taking paternity leave. And I think that that is something that's really important. But just more generally in terms of things that can be done, I think just, flexibility is really important. And I think that focusing on output rather than face time in the office is really important. And it's difficult in private practice where performance is so often measured by billable hours and the number of hours that you work. But I think recognising people's contributions in terms of the quality of their work and the outputs they're achieving is really important. And I think you can have the best policies in the world, but ultimately it comes down to your individual managers and supervising partners and the people you work with in terms of creating a culture that is supportive of working parents. So I've just been really fortunate in that respect. I think it's easier when you do work with people who been through what you're going through or might have kids themselves and are closely aligned with all of those considerations.
You've really hit the nail on the head there in terms of it being such an important cultural issue. Hearing a lot of anecdotal stories of particularly fathers feeling the pressure not to take parental leave, and that being something that culturally really needs to change within the industry as well. Turning now to the paper that you decided to write on maternity leave, and that was on the proportionate liability scheme in Queensland. What made you decide to write the paper on that particular topic?
I think initially I thought it would be interesting to write something with a focus on Queensland, particularly given the conference this year was held in Brisbane with a lot of guests from interstate. And I've always found it really interesting that Queensland's the only state that expressly prohibits parties from contracting out of proportionate liability. And there were two pretty significant cases, both with quite surprising results last year. And the implications of those cases, I thought, were particularly acute for people in Queensland that can't contract out of the regime. So I thought it'd be interesting to look into further and to write about.
You mentioned Queensland prohibiting contracting out. Are there any other key differences between the Queensland regime and the other states and territories?
Yes, there's actually quite a few differences between all the different states and territories regimes, and that I think is an unfortunate thing that makes this area even more difficult than it already would be. But in terms of the other significant difference between Queensland and other jurisdictions is the way that the Queensland regime defines what is an apportionable claim, so a claim to which the proportionate liability regime applies. In most other jurisdictions, or the first limb of an apportionable claim is a claim for economic loss or property damage that arises from a failure to take reasonable care. Whereas in Queensland, it's a claim for economic loss or property damage arising out of a breach of a duty of care, which might not sound all that different, but potentially is quite different because it presupposes the existence of a duty of care in a way that potentially the other regimes don't. And the Queensland regime also contains a definition of duty of care, which essentially means a duty of care in tort or a duty of care in contract that's concurrent and coextensive with a duty of care in tort, or a statutory duty that's concurrent with the duty of care in tort. And so it does leave open this possibility that you can actually avoid triggering the Queensland regime in the first place if you don't have a concurrent duty of care in tort, which is actually a really difficult issue that the courts have grappled with for a long time, with lots of different decisions that go different ways as to when there is a concurrent duty of care in tort. And so ultimately it actually just makes the regime in Queensland arguably have narrower application, but still leaves a lot of question marks around how it operates.
And what are some of the main implications then when it comes to construction contracts and how we deal with this in terms of drafting around the proportionate liability scheme in Queensland?
So a big focus of my paper was this torturous history of what it means to be a claim that arises out of a failure to take reasonable care or arises out of a breach of a duty of care. And so there was a case in the New South Wales Court of Appeal last year called Gerard Toltz and City Garden. And in that case, 2 of the 3 Court of Appeal judges flipped the script or cast doubt over what was previously the prevailing school of thought, that a claim was only apportionable if a failure to take care or a breach of a duty of care was an essential element of the cause of action. But in this case, New South Wales Court of Appeal case last year, those 2 judges said that that wasn't the case on their view, and that as long as the claim arose out of factually there was some sort of failure to take care or some sort of negligence, then that would mean that the claim is apportionable. And so that carries with it the risk that breaches of strict contractual obligations could be apportionable claims if they factually arose out of some sort of negligence. And so the position in Queensland is complicated because you can't contract out of the regime, but you potentially can avoid triggering the regime by just having no concurrent duty of care. And so I think what that means for parties in Queensland is to specifically turn their mind to whether they want to leave room for the imposition of a duty of care and tort, or whether they want to sew up their contracts so that you could say that there is no room left to impose the concurrent duty of care and tort. But that in itself is a complicated issue, because you often see clauses in construction contracts and in consultancy agreements that require a party to exercise due care and skill. And so those kinds of clauses, they're often expressed as in a way that's very similar to a duty of care in tort. And there are decisions in Queensland where that has been held to be a duty that's concurrent with a tortious duty, but those cases predate the High Court's decision in Brookfield. And so there's the possibility now that if you do have a really detailed contractual regime, even if it does contain an obligation to exercise due care and skill or to perform services with reasonable care, that doesn't mean that there is a concurrent duty of care and tort, because it effectively is a different standard. And so I guess that's all a really long way of saying that the position is complicated. And if you're in Queensland, you can't have a clause like you would have in New South Wales that just says that, you know, the parties contract out of their proportionate liability regime. But there are other things that you might be able to do to avoid triggering the application of the regime.
So in Queensland, it's going to require some really careful drafting in terms of trying to avoid the application of the proportionate liability scheme, and it's something that will require really careful consideration.
Yeah, that's right.
Now, your paper argues that Queensland should reconsider its stance on contracting out of the proportionate liability scheme. Why do you say that?
My paper says that the best outcome would be if we can achieve some national reform and harmonisation. But there's been a few efforts to do that over the years, and they've all sort of come to naught. So my paper says that the next best thing, if we can't achieve that, is for Queensland to reconsider the prohibition on contracting out. And the reason that I say that is that the mischief that it's trying to address really isn't clear. And so there's nothing in the explanatory notes or the second reading speech material that really explains why the prohibition is necessary. And when you go back and think about the policy objectives that proportionate liability was trying to achieve, it was about resolving or improving the availability and affordability of insurance. And so in circumstances where you contract out, I mean, most policies, most PI policies, for example, would contain an exclusion for contractually assumed liability. And so in that situation, it's not going to contribute to an increase in insurance premiums, because you wouldn't have insurance coverage to the extent you've got liability over and above what you would otherwise have by not contracting out. And so it seems like the policy objective for the prohibition might have been broader considerations of fairness, but it's not clear why those should trump voluntarily entered into agreements between commercial parties. And obviously proportionate liability applies across the board to any professional services essentially, and not just to construction. But in the construction context, obviously a lot of these contracts are worth several hundred million, if not billions of dollars. And so the uncertainty that the regime creates is an unfortunate outcome, particularly around issues to do with whether you can recover all your loss from your counterparty, or whether you're going to have to go after multiple parties and potentially have multiple parties to a dispute, or have multiple proceedings, which is worse still.
So now your paper also mentions the decision in Tesseract, which is another decision that upended the status quo or the mainstream thinking. Can you talk about what impact this decision has on the application of the proportionate liability scheme in construction disputes?
Sure. So I think upended is the right way to describe it, because prior to Tesseract, it was widely thought that proportionate liability didn't apply in arbitrations. And obviously the High Court in Tesseract flipped the script and said, no, it does. Well, it does, subject to what your contract says and whether you're permitted to contract out or not. And so the implications are pretty far-reaching, particularly for construction contracts and construction disputes where projects typically involve multiple different parties delivering the work. So the consequences are most profound in the construction context. What it really all means is that a plaintiff can't recover, or potentially can't recover, their full loss from the defendant and has to separately commence court proceedings after the arbitration against third parties to fully recover their losses. And that carries with it the risk of inconsistent findings and delay and additional expense. And I should say, obviously, that's because normally you can't just join a third party to an arbitration because it's obviously a private agreement between two parties.
So what strategies then can parties use to manage the risk of this in light of the Tesseract decision?
So I think parties who can will, I think, seek to contract out of the regime. So that's something that can be done in New South Wales, for example, and you do routinely see that done. For parties who either don't have the bargaining power to do that because their counterparty doesn't want to agree to that, or where they're unsure whether they can contract out. And so, as we've said, Queensland expressly prohibits it. And then there are a number of jurisdictions in Australia that are silent on the issue. And the prevailing view prior to Tesseract was that you probably couldn't contract out where the legislation was silent. And now post-Tesseract, given various comments that were made in the context of the South Australian and Commonwealth regimes, the situation is a bit murkier, but people think potentially you can. But when you're faced with that uncertainty as to whether you can or you can't, another option is to include in all your contracts for a project, if you're the principal or the upstream party, clauses requiring all of your contractors and consultants to agree to be joined to an arbitration or to agree to consolidate arbitrations that relate to the same project. So that's a strategy that can be adopted as well. For parties in Queensland, where Queensland is nominated as the place of the arbitration, there's this ongoing question around whether an arbitration agreement that excludes the Queensland proportionate liability regime from the substantive law of Queensland is going to be set aside as contrary to public policy. And there's not necessarily a clear answer to that question. And so one thing that parties might do would be to nominate another jurisdiction as the place of the arbitration, so New South Wales, for example, and also as the substantive law governing the dispute. But that does carry with it some untidy consequences in the sense that there are statutes in Queensland like the QBCC Act and the security of payment legislation that apply based on the location of the work. And so I think it'd be a bit messy to have a contract that is about Queensland or relates to Queensland projects that are located in Queensland and has that legislative overlay, but at the same time, the disputes are governed by another jurisdiction.
Yeah, definitely very messy. The easiest option is going to be if we can just contract out of it, isn't it? Which is what your paper argues.
Yeah, that's right.
Well, thanks so much for joining us on the show, Emily.
Thanks so much for having me. It's been a pleasure.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawana Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.